We are connecting now. Let's see what we've got in the audience. So far, just one person. Two.
We just started. It's
Yeah. We're just waiting for the full attendee audience to establish their connections, and then we can get started. So just a brief moment. Okay, it looks like maybe that's it for now. Do you want to begin the meeting, Chair?
Yeah. If I welcome everyone to the, let's see, which meeting are we on? November 19th. I don't know if we counted, but I wanted to actually start with thanking the staff for making sure that we meet every month. And it's starting to wear on me. I can't even imagine all of the work that you guys are putting into meeting every month. I'm sure, you know, with the times changing, with Zoom kind of being our regular new normal, the burden of preparing for these meetings monthly, that's difficult, and we do appreciate it. And I also want to thank all the commission members too, because you don't know this for a lot of the new ones, but we used to be able to kind of set things aside, but we're on a new schedule, a new pace, and it requires you know, attention regularly to check to see which updates are available. And I thank everyone for, you know, putting in time. With that said, then if you have any questions, then we'll just hold those off until we have the agenda item where we can take comments from the commission. And we'll go ahead and review the first item, which is the minutes.
I move to adopt the minutes.
Second.
Okay. With that, there are any abstentions or, okay, then we'll go ahead and approve those minutes.
Thank you.
Second item is the administrative matters, and we'll start with the report from our executive director, Brian.
Okay. Yeah, thank you, Crystal, for the kind words there at the outset. It is a different pace for us to go monthly, and we're simultaneously, Barbara and I are simultaneously staffing monthly meetings of the committee on the Division of the Penal Code. So we're going from one meeting every other month to 2 meetings a month. So it does stretch us a little thin sometimes. And that was really the only item I was going to talk about in the executive director's report, is that the December meeting might be a little light. We won't know for sure until we get there, but Barbara and I both have obligations that we're going to have to meet for the committee that are coming up. They are working on a model where they wrap all of their year's activities into a final report at the end of the year. And so we're going to get to the stage where we have to start drafting, compiling, proofing that report, which is going to be cumulative for everything the committee's done in the year. So that's going to take some time. They also are learning the pleasures of being a public entity. We've gotten our first public records request, and that's going to take some time to really nail it down and establish some good practices for the committee to follow. We don't usually get very many requests for the commission. I suspect it's going to be more active on the committee side. There's more public interest in that topic generally than what the kinds of things that the commission works on. So just letting you know ahead of time that it might be a light meeting for December. Still important. There's still things that have to get done by the end of the calendar year, but we might finish a little early. And that's
Brian,
report.
will the other committees reports be put into the same hardcover as ours, or will all be separate?
You know, we haven't finally decided that, but I kind of suspect they might be. Well, I don't know. I don't want to commit to that.
Okay, you don't have to give me an answer. I just thought it was an issue that we needed to think about vaguely.
Yeah, I mean, I think that I'll talk to the folks on the other panel and see what their thoughts are on that. Certainly there's some logic to it, because the commission is a body that is an umbrella for both the commission, the traditional commission, and the new committee. So it makes sense to compile it in our official volume of reports. There might be some care that would have to be put into adjusting some of our language and the way we structure those reports if we decide to do that. I think the thing is that the committee doesn't feel itself bound by the sort of the culture of the commission and its traditions. And so they may be looking at that report in a different way, and may not care as much about having an official record that's going to persist in hardbound books in libraries. So I'll let you know. So that's all I have for the director's report.
All right, and so for commissioner suggestions, Commissioner Rubin, do you have any suggestions? No suggestions? No one else? David does.
He's muted.
Commissioner Carrillo, do you have any? Go ahead and state your suggestions.
I just wanted to replant my flag on the hill for California citation style. Date goes in the middle, no spaces in the reporter abbreviations.
I'm looking at Brian.
Well, I'll repeat my position, which is we were going to evaluate that at the end of the year so that we have uniformity in our existing set of documents prepared for this year. But I'll ask you, David, is that the only aspect of the California citation style that you care about? I mean, because they have an entire manual.
Yeah.
And, you know, if that's the only thing you care about, and it's decided that we can tolerate sort of partial adoption, then it would certainly be an easier transition for staff.
That is my request, as God intended it to be, with the date in the middle and no spaces in the reporter abbreviations. I understand that many people object to switching to strict CSM because it is onerous. It has a lot of extraneous punctuation that neither I nor anyone outside the courts feel is necessary. I would only use it myself if I were filing a brief in the California Supreme Court, because it's what they're expecting to see. But everybody else in the real world, in my years of experience, they use the simplified version, which just means date in the middle, no spaces.
Okay, so I understand your point. Crystal, I see a hand from Commissioner.
Yeah,
Rubin,
I do too.
who is muted.
Yeah, you're muted, Rick or Rich.
Okay,
Go ahead.
thank you, Bob. Crystal, I wanted to just make one point in that I want to compliment Barbara in particular for
She's blinking her eyes.
for a very comprehensive memo that she wrote on the Commission Authority. I think it's a very well thought out, very thorough, very extremely well researched report. I sort of was responsible in part, at least, for stimulating that response. And so I want to express my gratitude for having you, Barbara, and for the board taking the time to look into this. And I feel very comfortable now that we have established a legal foundation, which we already had done previously, but which now reads well and brings forward a lot of history, which I'm not sure I, as a new commissioner, knew much about. And so I'm thankful that we did that. And again, my kudos go out to staff for doing that work.
Well, and you know what you'll find is they're so talented, and I'm just piggybacking on what Commissioner Rubin just said, Barbara, but you'll find like Kristen has a talent. You can read what they write and you can usually identify who wrote what. And it's something that I think we love them for, really, because they do a really good job. But I'm sorry, Barbara, to interrupt you.
Well, I was just going to say thank you. I'm very, very pleased that you think the memo was an answer to your questions.
Thank you.
And it has some value beyond answering an immediate question. I mean, in part, you said correctly that it's good for new commissioners to see some of that historical material just in general in terms of understanding the sort of the history of the commission and its at its founding. But it's also helpful. We write these kinds of memos every once in a while in response to questions raised by the commissioners, and it allows us to sort of build a little library of materials related to the history of the commission. And so it's nice for the immediate purpose, but it's also nice to have it on the shelf. So if we ever get an inquiry that touches on that, it'd be very easy to just send them a copy of the, whoever's making the inquiry, send them a copy of the memo. So, you know, not, I guess that's all I have to say on that.
It was also, you know, kind of fun for me to write because it gives me an excuse to read some of the old materials about the founding of the commission, which, you know, I'd seen some of them before, but never when it was part of an assignment. So I never felt like I had the luxury to read them with the same care that I did this time. And it's good to learn more about the history of your institution.
Well, I think it's an ongoing exercise for this commission and the ones that follow us to simply be aware of where we've come from and where we may want to go. And that's a fair inquiry to make, and it's a fair one to bring up periodically to see that we're maintaining a consistency in how we treat these very, very important issues. That's pretty much it.
Yep, I agree.
All right, so the next, it sounds like we're in the spirit of Thanksgiving, this is good. We didn't intend the theme, but it is.
You don't get anything else.
It's nice.
Treat yourself to some pie or something.
Exactly. In your own safe little, you know, capsule. The next item is the meeting schedule.
Right, that's memo 2058, and it's got some proposed dates. And so really, the question before the commission is just, do you need to change any of those dates? And if so, then we can pull our calendars out and figure out what to change them to.
My 2021 calendar is blank. I ain't going nowhere.
You know,
Rick, you had a commissioner.
Yeah, 3 of those dates, the March, May, and October proposed dates overlap the already scheduled meeting dates for the Commission on Judicial Performance.
Okay.
So either the week
Are those one-day
before,
meetings or are they spans of days?
they are scheduled as 2-day meetings, Wednesday, Thursday. So either, you know, a different day of the week in that same week, or the week before or the week after work for me on any of those, any of those 3.
So I think the easiest and least disruptive accommodation would be to look at the possibility of pushing all those back to Fridays.
Sure.
Which would be March 26th, May.
21.
Yeah, I'm checking calendars as I go, and October 22. Okay, there's no state holiday conflicts. I don't have they don't release, Rick, when do they release the legislative calendar?
Oh, that'll be released probably should be in December.
When they swear in?
Yeah, well, they'll do the swearing in the first Monday in December, and then I think shortly after that they'll adopt the calendar, because generally the calendar is part of the rules, and they will typically adopt the rules the same day.
Yeah, so I can't check it against the legislative calendar except to use
Fridays are pretty slow on the legislative calendar.
Yeah. So
Yeah, Rick, with all due respect, and please don't take this remark as any criticism, but I was on 2 boards myself for a number of years because one governor had appointed me to nursing board, one governor had appointed me subsequently to law revision. And I had a discussion with the then appointment secretary, letting her know that situation, and her preference at that time as a different appointment person was that eventually I needed to roll off of one of them. And we decided there was no urgency for me to resign abruptly from the nursing commission, but I did roll off at the end of my term. And that was the preference of the prior appointment secretary. I don't know the viewpoint of this one, because she candidly admitted that we were known here at the commission as being one of the more labor intensive commissions. And then the other alternative, again, this isn't a criticism, Brian, you're juggling so many balls in the air with the committee and the commission that we could always build into the situation that Rick needs to miss 1 or 2 meetings
Right.
because your schedule is more important than any of ours.
And it's also the case that about half of the CJP meetings are 1 day and the other and half are 2 days. So if it's not practical for everybody to change them, I'll just work it out with the dates you have.
Rick also has 2 different appointing authorities.
Yes,
CJP is
I'm
from the
a
judiciary.
Senate appointee for CJP and governor appointee for Law Division.
And I'm on 2 commissions. I just juggle it and
Yeah.
it works out
So-
fine. Yeah.
Yeah.
So
I'm
I
okay
think,
with
I mean,
that.
I'm okay for Fridays, but you probably will come to a point where sometimes you are going to have to miss it. And if you saw how, let's see, like, some people will split the day. We've had commissioners who will either show in the morning and then, but I mean, now we're all on Zoom, so I don't know how you could juggle that, but
Yeah.
it's just a suggestion, but I'm totally open to us meeting on Friday. What I
I mean,
was
Jim
going to
probably want
suggest
me to
is,
do this,
what, is it too heavy though, Brian? Or should we cut back or what?
No,
You're good? Okay,
I mean, it's manageable and I think it's necessary to keep these studies going.
okay.
So I
It's
agree
also-
that I agree that it's okay for a commissioner to miss a meeting every once in a while, so long as we don't get too much of a coincidental overlap so that it jeopardizes the quorum. But if that were to ever happen, we could talk about it and deal with it.
Brian, my class this spring is going to be Friday mornings. I scheduled it that way because we usually have Thursday
Right.
meetings. But I think looking at this calendar, if we have a Friday meeting, it's only going to happen once during the semester. So it shouldn't be a problem for me.
So what do you want to do, folks?
Brian,
I'm fine with accommodating Rick.
Who's talking? Kristen?
one point of information. So there's actually a tentative legislative calendar that was just posted yesterday, it looks like.
I wonder if it's the one I've downloaded. Oh,
And to state the obvious, if the pandemic situation changes, we might revert to a monthly calendar again in the fall of 2021.
correct.
I'm not going to hold my breath on that.
Don't wish that on anybody. Yeah, no, honestly, the pandemic, we'll probably all be inside. Most doctors are predicting until through next year.
Mhm.
You're looking, Brian, so that we can vote on Friday or?
Yeah, I'm checking.
Or we
Um,
could be innovative and meet in person some meetings and still
No.
continue Zoom on a.
No,
Oh, okay.
no, that's a hard no.
It's a
Well,
traveling part too.
Let's
Vic.
postpone the issue of what to do once the meeting social distancing restrictions are lifted.
Yeah,
Do folks want to push these 3 dates over to Fridays? Does anybody have a problem with that?
I'm okay with it.
Fine.
Sounds
So
good.
it looks like consensus, we're all okay.
Okay, we'll make
Okay.
those changes.
Thank you, I appreciate it.
Thanks.
Let me raise a possibility. I'm more conservative with open meeting restrictions for this body than we necessarily have been with the committee, in that with the committee, I've done informal email canvassing of commissioners' availability in advance so that we don't have to coordinate calendars during meeting time. And I do that on the theory, in part because I've been pressed to do it, but also because I think it's defensible that the minutia of scheduling is not really the kind of thing that the Open Meeting Act is intended to cover. Would commissioners like me to adopt that practice next year for the commission? To just check everybody's availability in advance and then promulgate the calendar in the same way for a formal vote at a meeting after we've worked out everybody's dates?
I think that's good. Are you guys good with that? Okay, good. You have a
Okay.
consensus. Yeah.
Seems
Okay,
fine.
good, thank you.
All right. The next one is Barbara's memo on commission authority.
Okay, well, This is the informational memo that the commission requested on the commission's scope of authority, the process of obtaining additional authority and related matters. The memo examines the plain language and legislative history of the commission's governing statute, as well as the long series of legislative resolutions that relate to the commission's calendar of topics. And it also briefly discusses the statutory purpose of the commission and underlying policies. As the memo explains in detail, the process for determining which topics the commission's authorized to study is pretty clear and straightforward. First, the commission considers suggestions and reports to the legislature on what it would like to study. Then in each session of the legislature, a proposed concurrent legislative resolution is introduced, generally by one of the legislative members of the commission. That proposed resolution goes through, it incorporates the commission's calendar of topics, and it goes through the normal legislative process. In each house, the resolution is referred to the Judiciary Committee for analysis and approval before it goes to the floor for vote. Sometimes the calendar of topics is approved without any changes, just the way the commission wants it. Occasionally, and I apologize for my internet connection there, occasionally the legislature decides to make a modification of one kind or another to the proposed calendar of topics. And then the resolution becomes effective once it is approved by both houses of the legislature. The governor's approval is not required. So it goes, the authority becomes effective as soon as the second house gives its approval. In addition to the process I just described, topics can come to the commission by another route, which is at any time that it likes, the legislature can either pass a resolution, a concurrent resolution, or enact a statute with the governor's approval that refers a particular topic to the commission for study. For example, in 2006, the legislature passed a resolution that directed the commission to prepare a proposed recodification of the deadly weapons statutes. And the commission, that was a standalone resolution separate from the commission's calendar of topics. Under either of those two processes that I've described, it's the legislature who ultimately decides what the commission is authorized to study. The commission cannot make that determination on its own, but the commission does have the ability to influence the process by expressing its view on what it would like to study. And then one more point is worth mentioning, which is that in recent years, the legislative resolutions on the commission's calendar of topics have included an additional requirement, which is that before starting to work on any project in its legislatively approved calendar of topics, the commission must submit a detailed description of the scope of work to the chair and the vice chair of the Judiciary Committees, and also to the chair and vice chair of any policy making, any other policy committee that has jurisdiction of the subject matter of the proposed study. And that extra procedural requirement is intended to further facilitate legislative input on the commission's agenda and ensure that it spends its limited resources on studies that will ultimately be productive from the legislature's standpoint. And so this is just an informational memo. There's no vote required. Does anybody have any questions or anything that you'd like to discuss?
Good job.
Good job, Barbara.
Okay, that's that item.
I think we should probably like when we have new commissioners, I think I brought it up before and we might still do it with making sure that like we have an information packet or and this would be, I think, included or it should be included in it to help.
Yeah. We do a mailing, an email, at least now, of materials that includes background memos. And I would expect that this would be added to the portfolio of those. And that's
Yeah.
sort of the ancillary benefit that I was mentioning before, is that we can add it to our repertoire.
Mhm. Very good. So now we're on to the next memo, which is Brian's 2020-60 for interstate reciprocity. We have some participants too. I'm not sure. Okay.
I
You
think,
see them?
I think
Okay.
a large number of them are probably here for this item.
Okay, good.
This is the companion memo to the memo that Barbara wrote at the last meeting. This is 2020-60. At the last meeting, when we were considering new topics, one of the suggestions we received was that the commission look at the issue of interstate reciprocity for distance learning at post-secondary institutions. And the decision was made that we would revisit the issue at this meeting with one memo talking about the existing law on the commission's authority generally, which is what Barbara presented, and then the other more specifically presenting some language that could be used if we were to decide to request authority to study this topic. That's this memo that I'm presenting. So there are a couple of decisions that are going to come out of this. One is, does the commission want to request this authority? And then the other is, if it does, should it use the language that the staff proposed in the memo? And then sort of ancillary to that, because at the last meeting, we talked briefly about conflict of interest and disqualification from decision-making, I decided that it might be helpful to include a little bit of sort of focused discussion of how that works and the extent to which it would apply to this study, given that some of our commissioners are employed by public institutions of higher learning. And my conclusion, as explained in the memo, is I don't think that that's a conflict that would be disqualifying. The law generally is pretty technical in this area in terms of the statutory disqualification rules. It's grounded in very specific statutes and regulations promulgated by the FPPC. And so you have to walk through this mechanical analysis when you're thinking about whether you're going to be disqualified. And so I attempted to do that in an sort of semi-abstract way with an eye on the issue of receiving a salary from a public university or college in California. And at the end of that analysis, my conclusion was, no, I don't think anybody has to worry about it. I think that you don't fit within the keyhole for what would be disqualifying. And I don't intend to discuss that in detail beyond this, unless a commissioner has a question about that. So in terms of what I will be discussing, I think it probably makes sense for the commission to decide first whether it wants to request authority to study this interstate reciprocity issue before we turn to the question of how to request the authority. Because if you decide you don't want to, then the second question is mooted. And I believe that some of the folks who are in our audience are here to speak to that question.
David, you know, and I'm looking through the names. I'm not sure who, Brian, on the attendees.
Well, we'll wait, and when you ask for comment, I'm sure they'll raise their hands and we can enable them to speak.
Okay, and then David, you wanted to make a comment right now?
I had a threshold question for Brian. I'm generally interested in studying this issue, and I before we dive into discussing whether we should request authority. I was wondering if you had any thoughts on whether there's a downside to requesting authority. If there's no downside and people are interested, then why not?
Well, I think that requesting authority obligates us to do something about it. I mean, it's not a hard legal obligation. We do have things on our calendar of topics where we request authority, and due to ever increasing priorities elsewhere, we never got to them. But I feel an obligation to try to work on it. And
Would that be
I
a
think
problem?
that, not if we can work on it, but I'm just saying it adds an obligation that doesn't currently exist. I don't think we can just ask for the permission and then assume like, well, we'll do it or not do it. I think if we ask for it, we probably should push to do it.
I just want to make sure that if we get it, that's not going to be a problem.
I mean, I think it's going to be a big study. I think that there is a lot of law and administrative information that's going to have to be collected and understood, and then somehow translated into a proposal. So I don't think it's going to be small. I think it's going to be something that would be with us for a year or two, and that would probably consume an attorney for that time period. And so it might be a little hard to squeeze it into our current workload, but not impossible. It would just mean sort of putting some other things on slower tracks or opting not to do things we might otherwise do.
One more question, which is, tell me if you have a concern about going to the well once too often. Are there other things that we're thinking about asking the legislature for? And we don't want to burn a request with this and potentially preclude other things.
I don't think that's an issue.
Okay.
I don't think they have that kind of sense that they're doing us favors that we're using up. I think it's more that they look at each individual suggestion, think about whether they are comfortable with it being a good fit for us. I think that, so it's possible that this would get to the legislature and fail. They would say no. Because I do think that there is some organized political concern about efforts in this area. I think they would be mitigated in part by the way that I've proposed to frame it, to look at the issue in the abstract rather than grounding it specifically in the SARA agreement. That's where I think the concern would fall more if they thought that our study was going to produce a recommendation for in sort of implementation of vanilla SARA in California, then they might decide to not have us do that if they don't want that outcome. So it's possible that they would just decline it. The only other thing I would add about this, I don't know a lot about this area of law at all. We're going to have to be learning it from scratch. I don't think we've got anyone on staff with expertise in this. And it was interesting to read the letters that were in the supplement to the memorandum, where the individual schools were talking about the difficulties that they had, and also the letter from TCUS. I'm going to have to learn the acronyms, sort of cautioning about some pitfalls in this area. One of the things that I foresee as a potential obstacle to success is that I think that this study might well lead us into the necessity of recommending some sort of significant state administrative government entity creation, right?
That's a
I
big
said
ask.
that badly, but I think it might be necessary to create some body or assign functions to an existing body that would have a price tag associated with them. And that's not the kind of thing that the commission usually does. Usually the costs of our proposals are pretty absorbable.
Maybe that's across the bridge when we come to it.
Yeah, but that's
Well,
right.
And then I was thinking because, and again, the newer commissioners haven't seen this, but Brian has access to, we could have maybe found a member who would have been willing to kind of spearhead changes to the law. And then that would have also helped us to have a charge or a responsibility to study this area. And then it could have, any recommendations that we could have made could have been, we would have had a more favorable audience or an appetite for it on the legislative side. We don't have that. And then we also have the barrier of COVID where Brian can't walk down the hall, or we can't have a member come in and sit in on a meeting. So I see, I mean, the letters were very interesting because it definitely highlights the need for it. But I think the letters, to me, signal an issue for lobbying that is outside our wheelhouse. I don't know how the rest of you guys felt. No comment?
I would, can you hear me?
Yes.
Yeah.
Okay. I understand your concerns, but I think that given the importance of the subject matter and the fact that we could bring clarity to it, I think it's worthwhile for us to explore it. Because in no way are we predetermining what the conclusion will be. And just the journey will help legislators and even lobbyists better see the issues. This is of critical importance to the state, to the higher education community, and I think we could add value by just looking at it. Again, I reference our work on the mediation confidentiality,
That's exactly what I'm thinking.
which was extremely helpful. You know, the state was kind of stuck in a place about what we were going to do about mediation confidentiality. We spent 4 years, Barbara, thank you, looking at it. And at the end, we came up with a recommendation that was rejected. And one could take that as a failure, but that was actually a success because the discussion that we had and the incredibly robust research that was done over the course of 4 years, looking at 50 states, helped a bill to rush through the legislature that kind of resolved issues that have been percolating for many decades. So I see our value as a commission in looking at things and not necessarily wanting specific outcomes in terms of specific statutes or statutory language, but just in furnishing the backdrop for legislators to actually do what they want to pass in light of other concerns that really aren't on our plate, such as the interests of lobbyists and things like that. With that said, Brian, can I ask this sort of an unusual question, but I think you'll understand where I'm coming from. Would it be unusual for the commission to, let's say, issue 2 sets of recommendations? For example, here's an issue that I know some of you may not be familiar with. There's a schism between the for-profits and the nonprofits with regard to where they want SARA to go. So could the commission, in theory, issue one recommendation if the legislature chooses to treat these 2 types of entities differently? We would recommend these sort of statutory emphases or language. And should the legislature choose not to treat these 2 sectors equally, we would recommend this alternate stuff. Would that be highly unusual? Would it be incumbent on us to actually put it into our recommendations whether or not to treat the nonprofits and the profits separately?
But I think that question is premature, Victor, because that's like when we would get to the point of making recommendations.
Well, but my point is,
years away.
if it's forbidden to do that or highly unusual to do that, that would weigh in favor of not proceeding with the study. I mean, that's a very political, non-intellectual on some level decision to make. Just a flat out decision of whether or not the legislation we're recommending will be applicable to both profits and nonprofits. So if what I'm saying against what I'm advocating myself is that I want the study to go forward, but it could be too explosive if the commission were to come out on one side of that debate definitively. And if that is a problem, that may speak to why we wouldn't want to pursue that study?
It's unusual. It's not unprecedented. Now, I can't readily think of an instance where we chose to sort of bifurcate our recommendation based on different legislative determinations when we had been authorized or directed to study an issue generally without specific limitation or guidance on that kind of an issue. But I can tell you that the example that springs to my mind is that we got an inquiry from legislative staff some years ago about an issue that had been bouncing around in the legislature without resolution. There's several iterations of bills having been introduced and failed in committee. And this inquiry was whether we could take a look at the subject. And the reason that it was having so much trouble was because it, is controversial and it was sort of fundamentally political. The question had to do with charter schools and whether or not a charter school that's formed as a nonprofit corporation, therefore a private entity, still part of the public school system, but organized as a private entity, whether those schools should be immunized from tort liability as if they were public entities. So under the then Tort Claims Act, should they be treated as public entities that would limit their tort liability and give them some immunities? And the inquiry was, well, could the commission, what would you think if we were to ask you to study this? Since the bills are going nowhere. And my response was, I think that the answer to that is going to be contingent on legislators' views on some pretty basic policy issues. And that anything that we say would not necessarily carry the day if the issue is going to be decided by their positions on the underlying policies. And so what I suggested was that we be directed to study it, but not to make a recommendation, that we provide an analysis. And that is unusual for us to provide an analysis without a recommendation. But that's what they did, and that's what we did. And we walked through and we said, all right, so here are the possible ways that this could be handled. Here are the legal and policy advantages and disadvantages of each. And then we had a report that we could give to the committees and we'd say, okay, now decide what you want to do. You understand, we've done the thorough analysis. You understand what the consequences are of the different options. Decide which option. And, they decided status quo, which is they're not governed by tort immunities.
But that study, Brian, I have met, and I'm sorry to interrupt you, Victor, but that study is almost like the leading resource for charter schools. I regularly meet people who say, oh, yeah, the commission. And it's like, I had never experienced that before, where they would know us, they knew who wrote it. It helps when you're writing briefs in that area. It has come, that one was, to me, you talk about successful, that was a successful study. And that was just us analyzing. So I wasn't necessarily in favor of us looking at Sarah, but if we did an analysis, even though we hadn't been charged to do it, I probably would be in favor of that. Barbara, do you have a comment?
Yeah, another example that's, not on all fours with what Victor is proposing, but somewhat similar, is that there was, the legislature directed us to study the forfeiture by wrongdoing exception to the hearsay rule. And at the time, there was a California Supreme Court decision that went one direction, but that decision had been appealed to the US Supreme Court, and there were decisions from all over the country going every which way on what was a pretty important issue. And the commission was given this assignment to look into that hearsay exception and also to report back to the legislature by a certain date. And it was clear at the time that the US Supreme Court would not decide the issue by that date. And the commission wound up writing a report that said, you know, you can't really, recommending that the legislature wait until the US Supreme Court had decided the constitutionality of the particular approach that was, there were several different approaches, but one of them was potentially a constitutional problem. And so the commission wrote a report that described several different approaches and made a recommendation, but the recommendation was wait until you see what the US Supreme Court does, and submitted that at the time that it was required to submit its report. And then what happened afterwards was that the legislature never referred the matter back to the commission to say, you know, okay, now that we know what the US Supreme Court said, which of these approaches do you want to do? By that time, it already had the information that it needed to make its own decision on what to do, and it enacted an exception with certain parameters. And, you know, so the commission's report was helpful to it. The approach that had initially been proposed in a bill by the legislator, that the bill that led to the study coming to the commission, that approach was not constitutional, according to the US Supreme Court. And so, you know, the commission's report was helpful in saying, hey, hold your horses, wait until you see what the constitutional ruling is. But the commission didn't actually have to choose between what were potentially controversial choices.
Yeah, that's really a great insight. And from what Barbara and you, Brian, are saying, I would think that we would want to, if we can, write this more advisory sort of report. I was in no way advocating for a dual recommendation. I just was bringing it up as a possible solution. I think it would be good to do the advisory report. Again, the market and the educational sector really needs some guidance in this regard. But at the same time, I'm worried that we do not have the political jurisdiction, for lack of a better term, to make that ultimate decision as to whether or not to treat nonprofits and profits separately. And I would want to avoid that determination if we could, particularly, and hearkening back to your conflict of interest analysis, I believe that the commissioners who are tied to the educational sector are all on the nonprofit side. To my knowledge, none of the commissioners work as adjuncts or full-time or otherwise for a for-profit. And that would undermine our credibility, I suppose, if at least 4 commissioners from my count were fully nonprofit people, and the for-profit people would be chagrined, I would imagine, if the recommendation was strongly nonprofit oriented. So with that said, although it's unusual, I would hope we would move forward with the study, but make it vague, as you said in the memo, but also make it more of an advisory nature and explicitly avoid the question of whether or not we think nonprofits and for-profits should be treated separately.
Specifically,
Kinda looking
avoid
at you
that
guys.
question, you said?
Well, I'm not saying we need to put this in the charge to the legislature,
okay.
but that well, it would be awkward if we were to ask, if we were to make a recommendation that was strongly saying, here are the rules for how nonprofits can enter the interstate flow of education, but for-profits are not allowed to avail themselves of these statutes. That would be awkward. I'm not saying that we necessarily come out that way, but it would be difficult to come out that way, given that 4 commissioners are aligned with nonprofits and there's no commissioners aligned with for-profits.
Let me ask a clarifying question. the commissioners who are employed by colleges and universities in California, those are all public institutions, right? Not private nonprofits.
I'm University of California.
And Commissioner King is CSU, and Commissioner Kubas is Community College District, right?
Commissioner Rubin had something of some kind.
Prior employment, I think.
Okay.
Repeat that question.
When you were employed by a university or college in California, was it a public institution or private?
They were public institutions with one exception.
But
Yeah,
that
I
was
have
prior
some
employment.
I have private connections too that I end up doing work for. I did some work for Stanford and then also maybe for Occidental. So I don't know, but I don't see that as being an issue though. If we just do an analysis, we'll be fine.
Yeah. The distinction isn't private, public. The distinction is profit, nonprofit. There's a huge schism. Obviously, the nonprofits want to create laws that say the for-profits should have more difficulty. And I don't think that's just necessarily greed. There's a sort of underlying belief that the for-profits would exploit private information of students for commercial purposes or for cross-marketing purposes more so than the nonprofits would. That's historically probably true, that the for-profits have exploited confidential private information of
Have you?
students more aggressively than the nonprofits did.
David,
Would the chair entertain a suggestion that we take the sense of the committee on whether we should move forward with looking into this issue?
I think I'll second that. By show of hands, who's
Yep.
interested?
No, well, wait, we need to have a discussion after first and second.
Well, this is just taking the temperature. That's it.
Yeah, I'm not making a motion to
Yeah,
have a
there's no
vote.
motion.
Brian presented this as, should we continue to talk to this preparatory to me actually explaining it to you? And I think we've reached the stage where we can decide whether we should hear from him or not.
Yeah.
Well, what about the members of the public that are here to
That's what I was going to ask.
offer their?
They don't have any hands up.
Well, you weren't, they
Give them a
weren't
chance.
invited to.
Well, but also too, we're just
Do
talking,
a
this is
straw
just among
poll.
the commissioners. I think I'm the only one actually who had some issues. I saw Jane's head nod. Anna, are you interested in pursuing this? And then Rick and Richard, you guys are too?
Yes.
So then, yeah, then we should just continue to discuss it. Are there any members of our attendees that would like to add some suggestions?
This is speaking to the question of whether the commission studies this topic at all.
Well, no, I was actually addressing the issue that you raised, Brian, because you were bifurcating it. You know, does the committee even want to hear about this issue preparatory to ultimately deciding whether we're going to request authority? And it sounds like everybody's interested in hearing the contents of your memo, and then we can get to the question of, are we going to request authority? I'm on the
Okay.
first part.
Um,
Can I ask a question? What would be
Yes.
the desirable end result of this discussion if it is to continue?
It would be a decision on whether or not to request authority from the legislature to study this topic, which would then, I think, lead to a study of the topic.
And in your opinion, Brian, does the legislature need, require, wish, want some further mandate from us if it chooses to go ahead and do this?
I don't understand the question.
These issues are not a case of first impression. They've come up before. There's been discussion in the legislature over many years about some of these issues involving charter, non-charter schools, public and private education. It's an appropriate discussion to take place in that chamber, in both chambers of of our legislature. My question is, can we add value to that conversation by however we end up in this, with the results that we are going to produce? That's my question.
I would think we could. I think that it's my sense, and this is a mostly naive impression because I don't know this area deeply, but it's my sense that this issue of reciprocity has come to the legislature in the posture of, should we participate in SARA? And so, you know, they have not agreed to do that. But at the last meeting, we discussed the possibility that there might be some other approach that could be used to reduce the costs and difficulties of interstate distance learning by California schools in other states and vice versa, other than SARA, that would not compromise California's control over regulating student protections. And I suspect, I don't know, but I suspect that no clever alternative approach has been presented to the legislature, and that they don't have the resources that we have to mull the matter deeply enough to come up with a fleshed out alternative to SARA. And so they probably are, I guess what I'm saying is that they probably have considered the SARA question sufficiently for their decision on whether to endorse that, but they may not have considered an alternative that we could come up with through our deliberative process,
Okay.
if there is such a one.
There's a question from Alex Graves in our attendees.
All right,
We might as
so
well just
you
take
ready
it.
for that? Then I will allow Alex to speak. There you go, Alex.
Hi, good morning. How are you?
Good morning and welcome back.
Thank you, and good to hear that the chair's done some work with my alma mater, Occidental. I'm always excited to hear folks working with my alma mater. Appreciate the conversation, and you know, I think you all have kind of fleshed it out fairly thoroughly today. Obviously, you know, on behalf of AICCU, which represents over 80 independent nonprofit colleges in the state, and is the one, you know, who, on behalf of our president, submitted this initial request for the last meeting that kind of spurred where we are now on this. You know, we remain very interested and supportive of the commission choosing to add this to their request for authority for study. I think some of the questions you all have been discussing amongst yourselves are certainly things that should be taken under consideration. You know, should the commission look into this? You know, when we shared after the last meeting that this was under consideration, obviously a number of our member institutions were very interested and wanted to submit some perspectives from kind of on the ground as to the challenges the lack of any resolution on this issue presents currently. And I think you see that reflected in the letters that they submitted and that we shared with staff. You know, I think the executive director, you know, raised some questions that would need to be figured out, you know, around, or some of the potential challenges, I should say, around, you know, does this require either a new government entity or new duties for a government entity, and what kind of costs does that create? And I think, you know, certainly that's an important consideration. And I think it's certainly feasible that in any structure that you all may ultimately consider, that, you know, for state or for entities that want to come in and operate in California, I think there's potentially opportunities to think about how that creates an opportunity to make this cost neutral. But again, I would leave that to the commission in your undertaking and review of this. But again, just really appreciate the conversation. You know, I again would reiterate that we're very supportive of something that's a broader study of this issue than just SARA, because I think we recognize where the SARA question stands in California and the legitimate concerns around, you know, consumer protections for students and what have you. And lastly, I would just say that should the commission choose to add this to their, you know, request, at whatever the appropriate time is, if and when you undertake this study, we'd be happy to make available our institutional staff who work in this area. We have a group of about 30 to 40 institutional staff who are part of a group that specifically works in this space, and we convene quarterly meetings with them. So I would offer up their expertise or just insights to help educate and inform this deliberation. So thank you very much.
No, that's very generous. Thank you. Do you want to go through the memo, Brian?
I am going to disable Mr. Graves, and sure, I mean, the only issue that remains in the memo is if the commission wants to proceed in this, in requesting authority, what language should be used to do that? The memo on page 2 presents draft language that could be used with or without modification. A couple of key features of the language that are explained there. First, it's broad. It is not limited to SARA. It would authorize the California Law Revision Commission to study, report on, and prepare recommended legislation to address interstate reciprocity for higher education distance learning. So this doesn't tie us to any particular approach. It just looks at sort of the underlying question, how to make this better. It's going on in the world, but as explained in the letters we received, it's got some sort of administrative costs and hurdles that are problematic. So it's broad. The other thing is it's unconstrained. When we get stuff pushed out towards us from the legislature, it sometimes has constraints attached to it, like a mandate, you shall do this, or a deadline, do it by this date, or specific micromanagement, like you shall consider this, 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 and this in your study. Those things happen, and when they happen, we manage them. We comply with the request. But I think in terms of language we generate and submit to the legislature as a request, we don't have to sort of anticipate that kind of thing. And my preference would be to have a clean resolution with no strings attached to it. They can attach strings if they want to, but I don't want to volunteer them because every constraint sort of complicates our task when we conduct the study. So those are the two features of the language that I've proposed. I think that the one possible modification that I think was suggested itself based on what Commissioner King raised this morning would be that you could strike and prepare recommended legislation from the language, in which case it would say, resolved that the legislature authorizes the California Law Revision Commission to study and report on interstate reciprocity for higher education distance learning. And then we wouldn't be barred, I don't think, from drafting language to say, here's something you could do, but we wouldn't be recommending it. So, you know, that's a possibility, to ask for language that basically charges us with preparing an analysis of the problem and possible approaches to the problem and the pros and cons of those approaches without settling on one as here's what we think you should do. I'm not advocating that. That's not in the memo. It just, the conversation we had this morning about whether or not we would be, for example, barred from offering multiple recommendations, and the example I mentioned of the charter school study as an alternative approach could be accommodated here. So I don't have anything else to say about it. You have to decide if you want to proceed, what language to use. And we would then look to the legislature and try and find an author who could introduce resolution language for us to implement it.
I think we go in asking for the whole shebang for the legislative resolution authority. And then, like you said, if it gets whittled down, and also too, letting them know that, I mean, we're not acting under any specific decision or in response or reaction to anything. We're analyzing something that's been presented to us, which we do have the authority. And it does seem like there's a need and that we could offer, and it's something that probably will come up. So even though I had some opposition before, I would say that I think we can obtain the authority and review it. Jane, you had your hand up.
Yes, you know, I've been just listening and thinking and listening and thinking. And so I really like the way, Brian, that you spoke about it, because I think that probably this is an issue that has a lot of different moving parts. And I think that maybe the best solution for us is to be more advisory instead of saying we're going to do this drafted language, boom, 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 that we're going to study it. We're going to throw out alternatives. We're going to, and then maybe then we wait for the legislature if they choose to direct us to do something more concrete. I don't know how other commissioners feel about that. It might be a better use of our staff time if it's going to take, I don't know. I mean, I know we're going to be really tight for time with, this is a pretty big topic and we have a lot of other issues. So, I'm just going to throw that out there. I mean, that would be kind of how I would lean toward it personally. I think it might be more productive as well to have those different discussions about, possibilities and then, move on from there. But I don't know how, I mean, I'd be curious to see what everybody else is thinking.
I was thinking too, I mean, you guys are down like half an attorney, or at least maybe even a whole attorney. This is a big study.
Yeah, it would be a big study. But on the other hand, it's an important topic.
Well, I say we move forward, but make the ask more of an advisory nature, as you suggested, Brian.
Rick, you had something you wanted to add?
Yeah, I think along the same lines as Victor just mentioned. My inclination would be study report on interstate reciprocity for higher education distance learning. And that sort of thing we can share with them, because this is, as I understand this is really a trade-offs between easy access by out-of-state and in-state, to other institutions around the country versus the consumer protection, data privacy kinds of things that California has felt strongly about. And so to the extent that our report analysis looks at the trade-offs on those competing interests, that can help inform the legislature as to whether they want to do anything at all, whether they want to consider some alternative to SARA. So that kind of a study makes me feel a little more comfortable.
Yeah, but if we had the legislative authority as part of what we're asking for up front, if the law could be improved by just either adopting or making a little tweak, then we could extend our recommendations to that end. Without it, and us creating our own constraints in anticipation that that's what would happen, I don't think that's how you ask for authority.
Well, I saw prepare recommended legislation as a constraint. So I was trying to remove a constraint, but.
No, I'm saying don't anticipate it, because we might be able to come up with, the study might reveal that we already have laws that will help to, if it had the removal of an or an and it could accommodate what we end up recommending. Or we're going to create our own limitations for no reason.
I mean, that's always a possibility that there would be a simple fix. My intuition is strongly the other way, because I think that this is an area where we're going to have to figure out how to thread a number of needles. One is going to be, what do the other states require? Another is going to be, what does federal law require? Because it's my understanding that a lot of these certification issues but for interstate education involve federal education law. I have already been sort of informally advised that there might be a dormant commerce clause issue embedded somewhere here. I haven't thought that through. I don't know that law well. So and then the other thing is that the SARA model, to the extent that I understand it, requires that each state have an entity that is responsible for administering that state's participation in SARA. And as I understand it, California is somewhat unusual in not having a state entity that regulates colleges and universities generally. So there's no obvious candidate for those duties. And so, if we were to look at some alternative to Sarah, it would probably still involve some kind of state function to sort of facilitate, because what the letters illustrate is that what we're trying to get away from is school by school coordination with every state, right? So there's probably I would imagine there's going to have to be some kind of clearinghouse function, right? That somehow that's going to have to be aggregated in order to reduce the costs and inconvenience of the existing piecemeal approach. We don't, I believe, in California have an obvious aggregation vehicle. And so I think that one would have to be created.
I think on the consumer side and that's what Victor was raising. So I give advice to alcohol dependency license certificate program school. So they're private, for-profit. And they do have regulation that I was like, where did this come from? I didn't even know this agency existed. So there is a vehicle for that area, but for the nonprofit, for the public, I don't know. But we might be able to borrow or look at it. I think once we look at and see what's going on, then we'll learn a lot more.
Yeah.
And then Alex's group, I think that's awesome if they could continue to participate as a stakeholder and help guide us through, along with, the work and help of the commissioners. It's going to be helpful.
Well, to
Yeah.
drive this to a decision point, it sounds like there's a consensus that we do need to move forward with a study, and that perhaps what we need to decide today is whether or not that request for authority will have the sentence create proposed legislation or not have that sentence. Is that right, Brian?
Yeah, I think that or any other changes that people want to make to the language, but approve some version of the language. And the idea I floated was striking the clause about drafting legislation.
Maybe a question on that, Brian. If it simply says the legislature authorizes to prepare a report, we're not compelled to, right?
Correct. By design, yeah.
Okay, then I'm okay with the language as it is then.
I am too. Do you guys want to move to vote, or are we all in agreement? David,
I call the question.
What specifically is the question?
that we move to adopt the language in the memo
As drafted?
as drafted.
That's my
Second.
motion.
Second.
Okay, all those in favor, say aye.
Aye.
Okay.
So it looks like it's it's a majority.
I have a second motion. Can we take 5?
Yeah.
Yeah.
I was kind of thinking about that. You guys hanging in there? Okay. We've only been working for an hour.
Hour and a half, but
So come back at 10:50. How about?